that's the CBN. It's a creation of statute, and therefore an agency of the federal government of Nigeria, whether two, the CBN is a public officer, and three, whether from the processes served on the bank, there is no indication from the consent or that the consent of the Honorable Attorney General of the Federation was sought and obtained before the order NISA was issued. All the above three issues will be determined simultaneously by latching on to the holding of my Lord Obandit versus Ogunya, JSC, who at page 19 to 26, paragraph F to D, answered the poser whether in garnishee proceedings, whether the Central Bank of Nigeria is a public officer within the meaning of Section 84 of the Sheriffs and Civil Process Act as to require the consent of the Attorney General of the Federation before garnishee proceedings can be commenced against it. He stated, and I quote, "It admits of no argument that the lower court erected its reasoning on the provision of Section 84 sub 1 of the SCPA, being the censor of the decision sought to be impugned. It is imperative to pluck it out verbatim, ac literatim, whence it is ingrained firmly in the statute book. Thusly, I think I will skip Section 84, 1, 3, 3A and B, and continue on with the holding of my Lord."
Mr. Court, please, madam.
He continued that indisputably, since the birth of the provision almost a century ago, the phrase public officer housed therein had been laying fallow in the wilderness of provision of Section 84 of the SCPA and crying for judicial definition by this court. Exultantly, it fell for construction in the celebrated case of CBN versus Interstellar Communications Limited, 2019, 7 NWLR, part 1618, page 294. Interestingly, the feuding parties place high premium on the ex-cathedra authority. In due obeisance to the expectation of the law, I have subjected the authority to a clinical examination with the finery of a tooth comb. Admirably, it is disobedient to willingness and ambiguity. Therein, at page 346 thereof, Ogumbi Ijesi, who spoke the unanimous voice of this court, proclaimed incisively, the other leg of the argument is where the appellant's counsel holds out that the CBN is a public officer and relied on the case of Ibrahim versus JSC Supra in particular. In the case under consideration, I've ruled that the relationship between the appellant and the third and fourth respondent is that of banker and customer relationship. In other words, as rightly argued by first and second respondents' counsel, the appellant is not a public officer in the context of Section 84 Sheriff and Civil Process Act. When regard is had to the history of this appeal, Section 84 has been reproduced earlier in the course of this judgment. It is apparent hearing on the facts of this case that the CBN acts as a banker to the federal government funds with respect to government funds in its custody. Section 2E of the CBN Act provides thus, acts as a banker and provide economic and financial advice to the federal government. Section 36 of the CBN Act also provides the bank shall receive and disburse federal government monies and keep accounts thereof. The appellant does not stand as public officer in this situation. Therefore, it follows that the need to seek the consent of the Attorney General of the Federation does not arise. I had at the terminus a core of this judgment cataloged the checkered trajectory of the first fourth respondent case, which eventually metamorphosed into this appeal. Incontestably, the appeal on CBN versus Interstellar Communications Limited. Council, can you mute your devices? Supra embrace each other factually. In other words, the facts and circumstances of that case share a striking semblance with and mirror those of this appeal. They are in pari materia in several respects. On this score, the law grants me the unbridled license to harness and borrow from the magisterial pronouncement therein on the footing of stare decisis, a doctrine propagated firmly in our corpus juris to ensure certainty and predictability in our acquisitorial system of adjudication, which was imported from the Anglo-American legal system. A federal government agency has been defined to cover all organs established by law through which the federal government carries out its functions. See Agbule versus WR and P Company Limited 2013, 6 NWLR Part 1350, 318, and 350. Thus, the fifth respondent, Customs, Immigrations, and Prison Service Board, is an agency of the federal government par excellence. In wearing the toga of that glorious status, it comes squarely within the firmament of ministries, departments, and agencies, MDS, that are mandated to maintain accounts with the appellant under the canopy of Treasury Single Account, TSA, policy of the federal government of Nigeria, CBN versus Schaefer 2025, 12 NWLR Part 2001. The import of the fiduciary relationship inter-parties is obvious. The appellant is not a public officer in the circumstances of the instant case, as contemplated by the provision of Section 84(1) of the SCPA and anatomized in CBN versus Interstellar Communications Limited, Supra. The settled posture of the law is that once a word or a phrase in an enactment has been judicially or statutorily defined, it bears that meaning assigned to it and drops its ordinary or technical meaning. It bears, put simply, the moment a word or phrase has received a judicial explanation or definition, a fortiori from the apex court, the courts are bound to kowtow to that meaning in subsequent proceedings. See Dapian Long versus Daria 2007, Shetima versus Goni 2011, RO versus Nyako 2014, AG Federation versus AG Lagos State 2013, Otumoto versus Ministry Governor of Bender State 2014, etc. This court, therefore, has a bounded duty. 2004, I beg your pardon. This court, therefore, has a bounded duty to follow and apply the definition of a public officer, which in deserving circumstances excludes the appellant. Under the provision of Section 84(1) of the SCPA, in effect, the learned appellant's counsel dazzling contention, which clothes the appellant with the undeserved garment of a public officer, is a quintessence of dressing the appellant in borrowed robes, which to all intents and purposes is a flagrant defilement of the basic tenets of the law, as chronicled supra. The bold fact that the appellant falls outside the perimeter of public officer as envisaged under the prescription of Section 84(1) of the SCPA given the peculiar circumstances of the case in hand, should shape and define the misfortune of the vexed issue. The reason is not far-fetched. The issue of consent can only germinate and flourish in a garnishee proceeding where a garnishee is a public officer under Section 84, sub 1 of the SCPA. It vaporizes where the law disrupts a garnishee of the dignified status of a public officer. Under Section 84.1, as in the instant case. This is because the procurement of consent is parasitic on the presence of a public officer. To this end, the heavy weather, whether the appellant met about, which the appellant met about obtaining consent does not merit the investiture of the scarce judicial time and space, which are invariably in short supply in judicial adjudication in this judgment. In the light of the foregoing juridical survey on the interpretation of the phrase public officer, which is resident in the provision of Section 84 sub 1 of the SCPA, the lower court's confirmatory finding is in total alignment with the hallowed principles of the law displayed supra on account of the circumstance of the case. It will amount to idolizing judicial sacrilege to reprobate and crucify a finding that has not disclosed any grain of hostility to the letters and spirit of the law. My Lord, Obande versus Ogunya JC, still at page, in the same case, 31 to 32, paragraphs E to C, added by way of obiter that there is a duty of court to disallow any act or application by a judgment debtor that stifles or intentionally delays the enforcement of judgment by judgment creditor. He stated, I quote, by way of a side note, let me state categorically that the reason they chair for the propagation of the judiciary is to fetch a decision. Decision is the final progeny, offspring, and product of any judicial proceeding or inquiry. Hence, it is not the intendment of the law to litter the pathway of a decision with insurmountable thorns and twists as valid passports to its enforcement. Such will demystify the majesty and sanctity of the temple of justice. At once, it will equip a successful party with a barren victory, as the possibility of reaping the expected fruits of judgment will continue to roam about in the expansive hemisphere of a pipe dream. It will please the rule of law to exercise any ounce of yoke planted along the route to enforcement of monetary judgment by dint of garnishee proceeding. A court of justice ought to wear this expectation like an emblem on its shoulder whilst adjudicating over garnishee proceedings. My Lord Habib Adewale Olumuyiwa Abiru JC at page 40, paras B to D of the same 2026 case elaborated on what the concept of justice entails, wherein my Lord held we must never lose sight of the fact that justice is rooted in public confidence, and it is essential to social order and security. It is the bone of society and the cornerstone of human togetherness. Justice is the condition in which the individual is able to identify with society, feel at one with it, and accept its ruling. The moment members of the society lose confidence in the system of administration of justice, a descent to anarchy begins. Justice Habib Adewale Muyiwa Abiru, JSC at page 40 to 41, paragraphs C to D to F stated further on duty of counsel whether lawyers can misuse their knowledge of the law and legal procedure to stultify the process of administration of justice. I quote what my Lord JSC admonished, that lawyers as operators of the administration of justice system owe a duty to the society as operators of duty to the society that nurtured them and made them what they are, to ensure that they conduct their activities in a manner that edifies and brings honor, respect, and belief to the justice system. They should not allow themselves to be used by litigants to bring the justice system into disrepute. It is pertinent that this court once again reminds counsel of the eternal words of a great jurist, J. Wesley McWilliams, who, writing in an American Bar Association journal in January 1955, wrote in an article he titled "The Law as a Dynamic Profession." Thus, we belong to an ancient, to a great, to an honored profession. The practice of law is a worthy calling. It has rewarded us with financial success and with prestige and leadership in our communities. It has given us much happiness and a good life. From it, we have received the gratitude and respect of our friends and neighbors whom we have served. Our work affords intellectual pleasure with dignity and independence in competition with our fellow lawyers with whom we have cemented warm friendships and enjoyed happy companionships. For these blessings, we cannot but have a sense of gratitude and of obligation. The most productive, unselfish, and unholy satisfying repayment of the obligation is constructive work to increase the effectiveness of our judicial system and welfare of the profession. Now, that's the end of the quote. Now, following the spirit of the said decisions, this court wholeheartedly adopts the crystal clear holdings of the Supreme Court, wherein my noble lords have gone through and resolved with a fine-tooth comb all the issues in the instant matter. I so hold that the garnishee, the CBN, is a creation of statute and therefore an agency of the federal government of Nigeria. 2, that the CBN is not a public officer. And 3, therefore, there's no need for the consent of the Honorable Attorney General of the Federation to be sought and obtained before the Order 9 was issued. Consequently, this judgment, this ruling is concluded with the holding of my Lord Obande Festus Ogbonia JSC at page 15 to 17, paragraphs B to C, who held that once a garnishee order nasi transfigures into a garnishee order of absolute, it crystallizes into a final order of court, not an interlocutory one. See UBN PLC versus Bonnie Marcos Industries Limited, Supra, ILO versus Geni, 2007, 17 NWLR, Zenith Bank PLC versus John, 2015, 17 NWLR, part 1458 at 393. Undebatably, in the legal sphere, a garnishee proceeding wears the flowing garb of sui generis, see FBN PLC versus Yegua Supra. Now, by this eliminating holdings of my lords, it is my view that there's really nothing left for the court to adjudicate, for this court to adjudicate upon, than to bring the proceedings initiated by the judgment's creditors motion ex parte dated 29th day of May 2025 to an end. In order to do this, I make recourse to the provisions of Order 56, Rule 1 of the Federal High Court Civil Procedure Rules 2019. And in the exercise of my inherent jurisdiction, as prescribed by Section 66A of the Constitution of the Federal Republic of Nigeria, 1999, to pronounce the Order 9 granted on 21st July 2025, pursuant to the case cited as a case authority cited above, having on the strength of the affidavit to show cause filed by the garnishee became absolute or becomes absolute by this event. The garnishee shall pay forthwith to the judgment creditor judgment debt arising from the judgment of this Honorable Court delivered in suit number FSC DMCS 21/2024 on the 13th day of November 2024 in favor of the judgment creditor applicant from the judgment debtors domiciled with the garnishee account domiciled with the garnishee. In its or any other treasury single account TSA with the garnishee in the name of the Nigerian Police Force or Police Service Commission on the strength of this order absolute. Is the ruling of this Honorable Court.
As the court pleases, thank you for the sound ruling, my lord. We are much obliged. Thank you, my lord.
Thank you. Call the next case.
Court, please. Charge number FPSC/DM/CR/2026 between the Federal Republic of Nigeria and Saleh Shagari and 5 others. Saleh Shagari, Haladu Malaki, Atiku Mohammed Lawal, Ibrahim Musa, Buhari Mohammed, and Hassan San. None of the defendants in court, my lord.
Representation.
Respectfully, my lord, S.A. Ibrahim. My appearance is for the complainant.
May it my lord. My name is I.M. Halle. My lord, my appearance is for the defendant.
My lord, this matter was adjourned to today for continuation of hearing, though the defendants were not in court. However, my lord, the defendants were released on bail on the last adjourned date.
Counsel, I'm trying to record you, so should be mindful of that. Matter adjourned to today for continuation of hearing?
Yes, my lord.
Yes.
Yes, however, my lord, the defendants were released on bail on the last adjourned date with the promise and undertaking to appear for their trial, my lord. And then, my lord, in view of that, my lord, we may hear from the counsel what is going on on the failure of the defendants to appear for their trial.
Yes, my lord.
Just a minute. Registry of court. Registry?
Yes, my lord.
Is the machines working?
Yes, my lord.
Recording proceedings?
Yes, my lord.
Okay, thank you. Yes, defense counsel.
Yes, my lord, that is the position of the case, my lord. My lord, I have been communicating with the respective sureties of the defendant since a day before yesterday, my lord. I was able to reach some of them, my lord. While some, my lord, I couldn't get them on phone. And my lord, most of the sureties, they do inform me that
Just a minute. Yes.
About 3 of the sureties, my lord, informed me this morning that the defendants are coming to this honorable court this morning in order to attend their trial, my lord. So in view of this, my lord, we shall be applying for a date, my lord, to enable us, my lord, put our house in order and in order, my lord, to ensure all the defendants be present in this court a day to their trial, my lord. A day to their trial. This is our humble submission, my lord. Thank you very much.
Yes. Prosecuting counsel.
Yes, my lord, we are not opposing to this application. We are not opposing. But my lord, if the defendants cannot appear before you, they are surety, my lord, they are surety, should appear. Their surety should appear to show seriousness, my lord, to show seriousness. But my lord, none of them appear now before my lord. None appear before my lord. Yes, but none appear. In view of that, my lord, we will reluctantly allow the defense counsel to at least talk to the shorties so that all the defendants should appear. But not even a single defendant, none of the defendants appear. None of the defendants appear. Thank you, my lord.
Give us a date. Register of court, give us a date. You are
27th,
muted.
or the 27th day of May, my lord.
You need ensure that it's a clear date.
Yes, my lord.
No case for that date, huh?
No case, my lord.
27th.
May.
matter is hereby adjourned to the 27th day of May, 2026. The defendants are to continue to enjoy the bail granted them till the next adjourned date.
As the court pleases.
As God pleases.
Charge number FSC/DM/CR/3/2026 between the Federal Republic of Nigeria and Habibu Saadu and 10 others. Habibu Saadu, Ahmadu Alaji, Muhammadu Baamala Bukar Kura, Mohammed Sani, Laminu Dairu, Isia Abdullahi, Idris Shaibu, Saidu Garba, Shaibu Abdullahi, Abdurrahman Suleiman, and Nuhu Ibrahim.
The case recorded, is that CR4 2026?
No, CR3, my lord.
What's the name of the first defendant?
Habibu Saadu.
Okay.
Yes, my lord.
Just give me a minute. Yes.
Yes, my lord. The first, that 8, 9, and 11 defendants are important.
The first, third, 8th, 9th, 10th, 11th.
No, no 10, 11. 10 is up.
Okay.
5 defendants are.
Just a minute. Making it 1, 2, 3, 4, 5 defendants in court. How many defendants in court?
5.
5.
Yes, my lord.
Okay. First, third, 8, 9, and 11.
Yes, my lord. Yes.
The
The remaining ones are.
second, first. The second, fourth, fifth, sixth, seventh, and 10th absent.
Yes, my lord.
Representation.
Respectfully, my Lord, S.A. Ibrahim, my appearance is for the complainant.
Yes, my lord.
My lord. My name is Akule. My appearance, my lord, is for the defendants.
I didn't, can you repeat that?
Yes, my lord.
Waiting for the presentation. I didn't hear, I heard the prosecutor, counsel.
Yes, my lord. And humility to my lord. My name is I.M. Ale. My lord, my appearance is for the defendants.
For all the defendants? He has disappeared.
With respect, my lord.
Yes.
Please, yes, I am AM Minor, my lord. I represent the 3rd and 11th defendants, my lord.
Okay.
Dependent number 3 and number 11. Yes, my lord.
Okay.
May it please this honorable court. My name is U.A. Muhammad, my lord, and also my parents for the first defendant, my lord.
Your name is?
U.A. Muhammad, my lord. For the first defendant.
Registrar of Court, can you mute your device? Mr. Halley is not yet back. I've not seen him on the.
Yes, my lord. I think he's having network challenge.
Because I want to confirm so far the defense counsel was for the 4th, 3rd, and 11th. So I want to confirm is Halley for the rest of the defendants.
Sorry, my lord. I'm having a network problem, my lord.
Okay, you are for. Mr. Halley, you are for whom? You are representing whom? Do we have inmates at the Pottiscombe Correctional Center? It seems we have.
Yes, my lord.
Still, Halley is having challenges.
Yes, my lord. He disappeared again.
Yes. This noise, is it coming from the correctional center?
Yes, yes, my lord. I asked the court registrar, my lord, Mr. Musa. I think I hear name for Abdurrahman Sulema. I think he is here at the correction center. Is it the one among the name that he listed before? I asked the.
Yes, there is number 10 is Abdurrahman Suleiman.
Yes, he's here at the correction center. Yes, technically. Yes, my lord. The defendant is present, my lord, at this house. Abdurrahman Sulema.
Okay, thank you, Mr. Salisu.
Thank you.
Okay. Khaled is still yet to join us.
Yes.
Yes, my lord. Sorry. My lord, my appearance is for the 3rd, 6th, 8th, 9th, and 11th defendants.
Mr. Halle, there's somebody here for the 3rd and 11th defendant. There's another for the 1st defendant.
Yes, my lord.
So you are for.
From what I have, my lord, from my record, my lord, I'm for the 1st, 3rd, 6th, 7th, 8th, 9th, and 10th defendant, my lord.
1st, 3rd, 7th.
Yes, 5th. I have 5th, my lord. 6th, 7th, 8th, and 9th defendant.
And the 4th. 6th. And Kevin, the 2nd defendant, the 4th, the 6th. And 10th defendant.
Yes, my lord.
I have not seen the representation. 1, 2, 3, 4, 5, 6, 7. Okay. Can you ask the 2nd, 4th, 6th, and 10th defendant where the counsel are? Register of court?
Yes, my lord. The defendants that are in court, my lord, are 1st, 3rd, 8th, 9, and 11, my lord.
I didn't hear you, Mr.
Yes, my lord.
Ndahi.
The defendant present here in court are 1st, 3rd, 8th, 9, and 11.
Can you repeat that? The network is not very good. I didn't hear that.
Okay, the defendant here are 1st, 3rd.
Mr. Ndahi, can you hear me?
Yes, I can hear you, my lord.
So what I have here is only for the 2nd, 4th, 6th, and 10th. I want you to confirm from them the 2nd, 4th, 6th, and 10th defendants where their counsel or where's
Why ni lawyer Ahmadu Alhaji Muhammadu da kuma Isiya Abdullah.
who is there? Ask him, go one after the other. Who is Ahmadu Alhaji Muhammadu?
One Ahmadu Alhaji Muhammadu. He's absent, madam.
Okay. Then the 4th defendant.
One Mohammed Sani. He's absent.
Yes, then 6th defendant.
Isiya Abdullah. He's also absent.
Also absent?
Yes, my lord.
Yes, and then the 10th defendant.
Abdurrahman Suleiman. He's at the
Okay,
correctional
it's the
center.
one at the correctional center.
Yes, my lord.
Ask him where his representative is, his counsel.
Abdurrahman.
Yes, Abdurrahman.
Abdurrahman, ina lawyer ka?
Abdurrahman, wai ina lauyanka? Suna son kotu kai. You say?
Suna can kotu.
He said that he said that his counsel is in court.
What is the name of the council?
Yes, he don't know the name for his counsel.
Yes.
My lord, in the interest of justice, my lord, I intend to represent the 10th defendant, my lord. And with your kind permission. Thank you. Being that he has no representation at all, my lord, I only make the bail.
Okay.
Yes, in view of that, my lord.
Just a minute. I need to record I'm trying to record him.
Spoken this.
Okay, thank you, Council. Yes. Yes.
Yes, my lord. My lord, in the absence of the second, fourth, and sixth defendant, we are not in court, my lord. And this trial cannot proceed without them. In view of that, we therefore, my lord, urge your lordship to still mandate their counsel to talk to the shorties who took them on bail for them to appear for their trial, my lord, on the next adjourned date. Thank you, my lord.
Date.
Yes, my lord. 27th May, my lord. May 27th.
This case is hereby adjourned to the 27th day of May, 2026. The defendants are to continue to enjoy the bail granted them to the next adjourned date. The defense counsel is to heed the advice handed down by the prosecuting counsel.
Much guidance. Thank you very much.
Saboda rashin zuwan wasu zan ɗaga shari'ar kuma za a ci gaba ana da 27 ga watan mai zuwa. Kaje ka zanna.
Watan biyar ke.
Watan biyar.
Do we have any other inmates?
Yes, my lord, we have one.
Okay. Oh, okay. Yes.
Sorry, 1 minute, my lord. They want to change something.
Okay. Council, just give the registry wants to be given a few minutes to resolve something. Did you notify them of the next adjourn date?
Yes, my lord. We will give them the date. We will write it and give it to them, my lord, on paper.
Emphasize to them. Anyway, they have their counsel. What is the challenge you are facing?
Yes, my lord. Malam Usman is trying to fix something, my lord, with the gadgets in the courtroom.
Okay, we can still continue. The ones we have missed is okay. I've recorded everything here.
Okay.
Yes.
Tax number FPSC/DM/CR/4 2026 between the Federal Republic of Nigeria and Aliyu Mohammed and 14 others. Aliyu Mohammed, Ibrahim Abba, Nasiru Lawali, Abdullah Hisani, Husseini Ahmad, Tanimu Muhammadu, Sani Ahmad, Murtala Abubakar, Nazifi Musa, Habibu Abdul Malik, Abdul Qadir, Muhammadu Rabiu Ali, Usman Abubakar, Sani Adamu, Idrisa Mohammed, and Abdullahi Ibrahim Mahmoud.
You have Abdullahi there. You're adding names that are not there. Number 15 is supposed to be Alhaji Ibrahim Mahmoud.
Yes, it's Alhaji Ibrahim Mahmoud.
I heard you calling Abdullahi.
Okay, sorry, madam. It's Alhaji Ibrahim Mahmoud. None
Yes.
of the important.
Okay. The names called, Mr. Salis at the Correctional Center, none of those,
Yes,
none
madam.
of the names called. Okay.
Yes, madam. The name is not here.
Okay.
None. Yes, my lord.
Representation.
Respectfully, my lord, Esther Ibrahim, my appearance is for the complainant.
Yes.
With respect and my lord, my name is I.M. Ale. My lord, my appearance is for the defendant, all the defendant, my lord.
Yes. Counsel, what are you waiting for? You are wasting time.
My lord, this matter was adjourned today for continuation of hearing, and none of the defendant is in court, my lord. In view of that, the court can hear from the counsel as to what is happening, my lord, to the defendants of their failure to appear before this honorable court.
Yes,
Mr.
that is
Hanley,
the
you're
position, my
wasting the
lord.
time of court. Why
Sorry.
should you wait for the
Sorry,
prosecuting
ma'am.
counsel to to submit first. While the defendants are not there and you are the one that admitted, applied for their bail, you're supposed to inform the court what the position, not wait for the prosecuting counsel to inform the court. Or are they not on bail?
They are on bail, my
Yes,
lord.
go
Bail
on.
was granted today.
Yes, go
Thank you
ahead.
very much.
Yes.
That is the position. The matter was adjourned to today for continuation of hearing, my lord. And all the defendants are not in court. But my lord, I was able to communicate today's dates to the sureties of the defendants, some of them, that this matter is coming up today. And my lord, neither the defendants nor the sureties are residing in Damaturu, my lord. And they informed me, my lord, that they are coming to court this morning. And none of them, my lord, is in court. So in view of this, my lord, and to save the precious time of this honorable court, my lord, I shall be applying for a date to enable us, my lord, put our house in order and to ensure their attendance in the next adjourned date. Thank you very much, my lord.
This motion is hereby adjourned to the 27th day of May, 2026. The defendants are to continue to enjoy the bail granted them till the next adjourned date. The defense counsel is to heed the advice of the prosecuting counsel.
As please.
Let's call the next case.
Thank you, my lord. Charge number OPS/DM/CF/5 2026 between the Federal Republic of Nigeria and Audu Hassan and 6 others. Audu Hassan, Muhammad Manu, Nafiu Abdurrahman, Masoud Aliyu, Dadi Ladan, Aliyu Abubakar, Suleiman Babayo.
That is CR5 or CR6?
CR5.
Okay. Yes.
Yes, my lord. Only the defendant.
Only the
Fifth defendant.
fifth. 5. That is Aliyu Abubakar. What is? Ask him his name. I didn't hear that. Okay. Thank you. Yes, representation.
Respectfully, my lord, S.A. Ibrahim, my parents is for the claim.
With respect and humility to my lord, my name is I.M. Halle, my lord. My appearance is for all the defendants, my lord, with the exclusion of the fifth defendant, that is Dadi Ladan.
Just give me a minute.
Respectfully, my lord.
Give
My
me a
name is
minute.
YY. And my appearance is for the lone defendant, my lord, Tadil Adan.
Mr. Hadley,
My lord,
you are for the first, second, third, fourth, sixth, and seventh defendants?
yes, my lord. And my lord, there is an observation.
Just a
The
minute. Okay. Yes.
My observation, my lord, is that the fourth defendant's name was struck out on the date of mentioning of this matter, my lord, Masudu Aliu.
His name, okay, was struck out?
Yes, my lord, on the application of the prosecuting counsel, my lord.
Okay.
From what I have here, my lord.
Yes, there's still another counsel.
Yes, my lord. YY Yusuf is for the fourth defendant. That's the true position as was stated by I.M. Halley. The name of the then defendant Masoud was struck out. Now my client now becomes the fourth defendant. That is Dadi Ladan, the one in court, my lord. Yes.
As for the fifth defendant then.
No, for the fourth, in the absence of the one that was struck out, my lord. Now the lone defendant in the dock now becomes the fourth defendant, my lord, Dadi Ladan.
Yes.
Yes, my lord. The first, second, third, fifth, sixth, and seventh defendant are not in court, my lord.
The first, second,
third, fifth, and sixth defendant, my lord, are not in court. And my lord, based on the information I received from the sureties, they are on their way coming, my lord.
Just a minute. I need you to still go with what is on my on the process. We have the first, second, third, fifth, sixth, seventh defendants.
Okay, my lord. Okay, my lord. The
Including
first,
fourth,
second,
so that there'll be no any confusion. First, second, third,
right,
fifth, sixth, seventh.
okay, my lord. The first, second, third, fifth, sixth, and seventh defendant, my lord, are not in court. And I received an information from the sureties that they are coming today. They are on their way, and they are not yet arrived, my lord. So to set the officials time, this honorable court, my lord, I shall be applying for an adjournment in order for us to put our house in order and to ensure their attendance in the next adjourned date, my lord. Thank you very much.
Contest hereby adjourned to the 27th day of May, 2026. Council, Mr. Hadley, now
My
it's
lord.
11:31, and defendants are not in court. You are telling the court that they are on their way. There's something wrong.
Honestly, my lord.
Because it's by 9 on the dot. Defendants, counsel is telling the court that counsel are on their way by 11:30.
Yes, my lord. That was the reason why I said, based on the information I received from the
Call the next case.
Thank you.
Charge number FSC/BM/CR/1 2026 between the Federal Republic of Nigeria and Pielo Alhaji Umar and 16 others. Pielo Alhaji Umar, Ibrahim Mohammed, Yusuf Umar, Mohammed Muntari Saleh, Rabiu Aminu, Haruna Yau, Ahmed Garba, Umar Ibrahim, Muntari Yusuf, Saidu Abdullah, Mudasiru Alhaji Isa, Isiaka Umar, Musa Mohammed, Idi Isa, Abdullahi Kabiru, Farooq Ibrahim, and Nafi Musa.
Yes, nice.
Yes, my lord. Only the 6th and the 12th defendants are in court. 6th and 4th.
Mr. Ndai, just give me only the
5th and the 12th defendants are in court.
5 and 12.
6 and 12.
6. Okay, the 6th. Representation, please.
Respectfully, my lord, Esther Ibrahim. Appearance is for the complainant. Respectfully, my lord.
Counsel.
Yes, respectfully, my lord. Esther Ibrahim. My appearance is for the complainant. Yes, my lord. S.A. Ibrahim. My appearance is for the complainant. Respectfully, my lord. S.A. Ibrahim. My appearance is for the complainant.
May it please my lord, my name is I.M. Hanle. My lord, my appearance is for all the defendants. My lord,
I've had it seems that the challenge is from this side because I can barely hear you. I've heard the prosecutor's voice and I've seen him. Any other counsel for this? Excuse me. Any other counsel, Mr. Halle?
Yes, my lord. I'm representing all the defendants with respect and humility, my
Oh, I
lord.
see.
Yes. With respect and humility, my lord. I am Halle is my name, my lord. My appearance is all the defendants.
Yes.
My lord, the defendants, both second, third, fourth, fifth, sixth, all the defendants, my lord, are not in court with the exclusion of the sixth and the 12th defendant, my lord. My lord, they are not in the reason known to them. My lord, this date, my lord, has been paid to their respective shop. And they are not before this honorable court. So in view of this, my lord, I shall be applying for a date, my lord, to enable us, my lord, put our house in order and communicate the date, the next adjourned date, my lord. And at the same time, my lord, I'm appealing to this honorable court, my lord, that the registrar of this honorable court, my lord, should my lord assist the defense counsel, my lord, in communicating all the adjournment date, my lord, to their respective sureties. Thank you very much, my lord.
This much is hereby adjourned to the 27th day of May, 2026. The application of the Defense Counsel is granted. That's adjourned.
Thank you, my lord.
The court pleases, my lord, we are much grateful. Thank you.
Yes, court
Yes.
pleases, my lord.
Sorry, my lord.
Yeah.
I want to confirm something from the correctional center. I saw one defendant standing, my lord. I don't know his name.
You're muted, correctional center.
Salisu.
Yes.
What is the name of that defendant?
Mutari Yusuf.
Okay, Mutari
Mutari
Yusuf.
Yusuf. Yes.
Okay.
Mutari Yusuf.
It's okay. Thank you, ma'am.
That's it. Okay, the nice defendant.
Thank you, ma'am.
Mutari Yusuf.
That is all we have for today, my lord.
How many cases do we have for tomorrow?
6.
Okay. Okay, thank you.
Thank you, ma'am.
Thank you all, counsel that appeared for this court today. Thank you as well, Registry of Court, Correctional Center. Thank you so much. Really appreciate, as well as Mr. Salisu and all staff of the Federal High Court. Thank you so much.
Thank you.
You're welcome, my lord. Have a nice day.
Wish you the same.
Oga, wannan amended charge naka nan.